Hey there, my friend. John Michaelides, Real Property Management at Sarasota Manatee. Life is good, and I hope you are too. I want to tell you about a very important issue. But before I get to the issue itself that we're going to discuss today, I got to give you a little background. So bear with the little instructional piece up front, and then we'll get to the point. So I remember the first day in law school, the property class, an instructor asked, what does it mean to own something? You own a piece of property. What does it mean? And people started answering, and when you start having that discussion, you realize that what does it mean to own something is kind of an amorphous, cloudy thing. What does it mean? It's a thought, right? It's just a belief. That's mine. It's not yours. Well, what does that mean in the eyes of the law? And what we learned is essentially what it means to own something is to have a bundle of rights with respect to that thing. So in terms of real property, the bundle of rights, there's 5 rights associated with what we call ownership. And in the law, we call that fee simple ownership. So if you have the entire bundle, then you have fee simple ownership. And the bundle consists of the right to possess, the right to control, the right to exclude, the right of something called quiet enjoyment, and the right of disposition. So to possess means you can occupy it. We're talking about real estate now, right? You can occupy that. You can possess it. You have that right. You can control the use. Now, everything I'm saying here is within the bounds of law. There's zoning, there's that kind of stuff. But within the bounds of the law, you have the right to control that property and what's done with that property. You have the right of exclusion. If it's yours, you can say who can and cannot access that property. You have the right of quiet enjoyment. That means any legal purpose whatsoever, you can enjoy and use that property to your heart's desire. And the right of disposition means you can sell it, you can rent it, you can get rid of it, gift it. So the 5 bundle of rights constitute ownership, and the way we have evidence of that bundle in real estate is a deed, right? We have a deed that says we're fee simple owners. That simply means we have those 5 rights. Now, what is a lease? A lease is an estate in land, just like you can have a fee simple estate, you can have a leasehold estate in land, and that simply means your rights are limited. You don't have a fee simple deed, you have a lease that gives you some of those 5 rights, but not all of those 5 rights. The important thing is you have legal rights with a lease, just like you have legal rights in the deed. The only difference is deed, full rights, lease, limited rights. When an owner leases the property, the owner gives up rights for a time period. They're not the owner's rights anymore. They're the leasehold estate holder's rights at that point. Do you get it? So when we lease a property, we have a tendency to think, oh, well, that's my property. Well, it is your property, but you have voluntarily limited your rights in that property for a time period and given those rights to someone else for a time period. For example, if you rent a house, you're giving the right of possession to that tenant for a limited time period. You no longer have the right of possession. You no longer have the right of control. Now you control it within the parameters of the written lease, but the tenant controls who can come to the property and stay and visit and this and that, right? So the control aspect is limited for the owner because it's partially handed off to the tenant. Same thing with exclusion. You can exclude who comes and goes, but now you're giving part of that to the tenant. So now the tenant has the right to exclude who they want into the property and out of the property within the lease terms. They have the right of quiet enjoyment to use that property as they see fit within the means of the law and the four corners of the lease. The owner has no right to quiet enjoyment on that property and disposition. Now, the tenant does not have disposition. They cannot sell that property. Owner retains full disposition rights, except they have to honor that lease during the leasehold period. But you see how the other four bundles of rights are severely limited when a lease is in place. All right, training session over. Here's a little scenario that recently came up. One of our owners, quite frankly, out of the blue, there was no prior discussion, announced that they bought a plane ticket, were coming down, were going to work on the roof and exterior of the property themselves, and they were going to place a big industrial dumpster in the driveway for at least a week. Well, we said, whoa, 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 whoa. Wait a minute. You realize you can't just do that anymore. I understand it's your property, but the tenant has rights. For example, they're renting the driveway. We can't just show up and dump an industrial dumpster on their driveway. Furthermore, the owner's not a licensed contractor. The owner doesn't have the insurance and that kind of stuff that goes with legitimate contractors, licensed and insured tradesmen. So there's huge liabilities. Now, us as property owners, we're in a very tight position because we take on the liability with respect to that tenancy and the lease. But here we're in a position where we're going to have unlicensed, uninsured people, even though they're the owner, working on the property. What if something happens? We're liable. So it's just a funny place to be. And believe me, I own rental properties myself. I understand that feeling of it's mine. What do you mean? I can do whatever I want. It's mine. There's limits to what you can do when there's a lease without the tenant's permission. They have legal rights in the property during that lease period. So what did we have to do? First of all, we have to give notice to this tenant, and they have to tell us it's okay to take away the use of their driveway for a week. Furthermore, as property managers, since we're not hiring the tradesmen, in this case, the tradesman is the owner themselves, but yet we're still responsible because we're the landlords on the lease. So we had to ask the tenant for a release of liability. They had to understand that, hey, look, we didn't hire these tradespeople. These tradespeople are there on the owner's accord. So you have to understand we don't have anything to do with this particular work. Then we had to get a release from the owner saying, look, if anything happens during the time you're working on the property, you agree to hold us harmless and indemnify us against any claims. You see what a funny, awkward spot this is for everybody? We're the property manager working in the best interest of the owner, now having to get a release of liability from the owner and the tenant because the tenant wants to go do work on their own property, not realizing that they don't really have the full bundle of rights anymore. It's just a sticky situation. Doesn't feel good for anybody. Now, I want to make clear, this owner was 100% good faith. They didn't realize. They wanted to come fix the property. Nothing wrong with that in theory. So just keep in mind that, things have to be done a certain way. Things have to be done with licensed and insured tradesmen. Proper notices have to be given that, yes, you may own the property, but you don't have the exact same rights during the period of a lease that you do when there's no lease and you have that fee simple ownership in full. Okay, sticky subject, but I hope that helped you, and I hope I educated you for not only your property with us, but other properties you may own now and in the future. Real Property Management of Sarasota Manatee, November 2019 owner update, and happy Thanksgiving in the U.S. all. Bye-bye. God bless you.